Thank you, Madam Chair. Sean Hoffman with the California District Attorneys Association, also in opposition. We share the court's concerns about workload and additional strain on trial court resources. We note that, in Gerstein v. Pugh, the U.S. Supreme Court held that the Fourth Amendment provides in-custody defendants with a right to a prompt post-arrest determination of whether probable cause exists to believe that he or she has committed a crime. California, in the wake of Gerstein, codified that in what is now Penal Code Section 991 to be a safeguard against the hardship suffered by the misdemeanant who's detained in custody by providing that probable cause hearing. The deprivation of liberty that seeks to defend against doesn't exist with respect to an out-of-custody misdemeanant. They're not in custody. The safeguard that protects that liberty interest is unnecessary and at the risk of increasing an already strained trial court system, both workload-wise and resources-wise. We would have to oppose AB 696.
Are there others in opposition to the bill? Seeing and hearing none, are there questions or comments from members of the committee? I would just have a question for the opposition. The Judicial Council would be fine. It would seem to me it could also decrease the workload if there was a speedy determination and you didn't have to go to trial.
So I think from the judge's perspective and the Judicial Council's perspective, even before, even as part of the process of arresting someone and bringing charges, there are some initial probable cause determinations made at that time. So I think the concern is that, and we can't say for certainty that it would be in every instance, but if the majority of these are building that extra step and there's already been some probable causes in place, I think they're questioning whether it's really, how many cases is it really going to weed out? So that's the concern.
Sure.
I'd like to ask the support.
Sure. Thank you. We do understand the concerns of Judicial Council. We do not believe this will be used in a fashion that will exacerbate the impactedness of the court calendar. First of all, we are not going to be. You cannot file frivolous motions, and so attorneys who bring motions that are likely to fail can be sanctioned. Second, DAs do a fairly good job of not prosecuting cases where no probable cause was found, but there are a few cases that slip through. When those cases slip through, we want to be able to have a mechanism to address that. We don't believe that it will be used in 10% of the cases or even 5% of the cases, but probably fewer than 1%. But for those individuals who are able to invoke this right, it will be a dramatic change for them in a positive direction of their experience with the criminal justice system. With respect to the court savings, we do believe that addressing these issues at the earliest possible time is going to be best for the defendant, for the court, and DAs and the public defenders.
Right. I can certainly see why it would be important to the individual that was charged. Senator Stone and then Senator Monning.
Thank you, Madam Chair. If I could have the California DA rep come back up as well as Judicial Council. Sir, isn't it true that the threshold for probable cause is low, and that it would be likely that you would see an attempt to paper a case to death?
The threshold for probable cause is low.
It's low.
I can't speculate as to whether there would be an attempt to paper a case to death. Certainly that's something that would be a concern. I think that Judicial Council mentioned that if there were a number of these where they ultimately found that there was probable cause, we'd be having 2 hearings instead of 1. So.
Would you agree that an overwhelming number of misdemeanor cases result in pleas and get resolved before they go before
I'd say a great
judge?
deal.
A great deal. And would you agree that this is going to be a burden to prosecutors and going to create a much larger workload?
We believe it will create a greater workload for us, so yes.
And what about 9/11 hearings? Would you say that this is going to dramatically increase 991 hearings, or do you think it would remain the same?
I think to the extent that they don't exist for this class of
Right.
defendants now, but they would in the future, I think it can only increase them.
Okay, so that's only going to burden the courts that are already dealing with Prop 47 issues. Would you say it congest the courts even more significantly?
I think that's probably better for the courts to answer.
Yes, that's our concern, that the courts are already very burdened with Prop 47 cases. In fact, the last count, I think we had 140,000 petitions. So adding a newer layer at this time certainly would be burdensome on the
And
courts.
can you elaborate on, you're mentioning that when a case is filed, that you're looking at probable cause already, right?
But those are for Prop 47,
For Prop
yes.
47. I think in Riverside County, we have 5,000 cases that are being returned to the courts to be adjudicated, which is having a dramatic effect on, you know, the ability to get before a judge, even
Correct.
for civil trials. So I kind of agree with your contention. This is going to significantly increase the cost for the courts. They have to accommodate, if you will, this additional step.
That is the concern.
Senator Monning.
Thank you, Madam Chair. So I want to come at it through a different lens from that of the accused. Neither the author nor the witness in support have mentioned for the out-of-custody accused, there's currently no timetable by which this probable cause has to be established. Is there any evidence that for that defendant, they can incur increased attorney's fees if they're indeed represented privately during the pendency of the lack of this determination? And wouldn't that represent an adverse economic consequence on an accused if they're eventually found that there's no probable cause, but they've retained an attorney who may be requiring payments until that determination is made?
That's an excellent point, and yes, that would be a particular hardship on that individual, especially when you talk about the fact that there's not just going to be one hearing, multiple hearings and consultation. So for those folks who are actually paying for an attorney, that's an additional hardship in addition to being involved in the criminal justice system for a prolonged period without any reason to begin with, yes.
Thank you.
Thank you.
So when we talk about costs, it's a balancing act of who's going to incur more costs. It just seems without any deadline now, the uncertainty could also have an adverse consequence. I would think in employment stability for an accused who has this outstanding, it could affect job applications, et cetera. So I think from a public policy point of view, this seeks to bring some predictability for the accused as well as for the courts. So I'll be supportive. Thank you, Madam Chair.
Is that a motion?
That's my motion, yes.
And I will say that the motion is due pass to rules to consider appropriations request to hold the hearing. So I think Senator Monning raises a very good point that we're talking policy here. Is it a good thing to have a time certain for these determinations to be made? Senator Leno.
Thank you, Madam Chair. First, to follow up on Senator Monning's point, and then going back to one that you raised, Madam Chair. The statement by the California District Attorneys Association in opposition does state that the deprivation of liberty for a confined defendant is the hardship that PC 991 exists to protect against. For an out-of-custody defendant, there is no such hardship. But I think the points that you're raising, and as Khalif had mentioned as well, there is indeed hardship, and this is trying to resolve that. I did want to see, following up on your question, Madam Chair, if the Judicial Council can tell us just approximately how large is this class of defendants?
I'm sorry, I don't have that information with me today. It's certainly something that I could get for you. But just in terms of the timing of it, it would be anybody who's arrested and charges are being brought, is my understanding, would be entitled to the probable cause hearing. So
Not in custody.
not in custody, exactly.
We have no way of knowing how large, because you made a very definitive statement. This is definitely going to be a hardship to the courts. You have to base that on something.
I don't have, well, let me look at because I do have some fiscal information in front of me. So according to the most recent filings, the information that we have is 926 169 misdemeanors filed in California. That's based on some information that we actually got from a sampling of the courts.
You're suggesting that this class of defendants could be near 1 million? This is a small subset of that, I would
So
imagine.
using the same ratio of in custody to not custody misdemeanor means in Fresno County, that would be a 10% to 90%. So the estimate is there would be 833,000 probable cause determinations potentially.
So we understand that the estimate generated by Judicial Council does tag it at a very high amount. I would say that in our association and among defense attorneys generally speaking, 991 motions are hard to win, so we're not likely to bring them very often except for in those very clear-cut cases. The standard for probable cause is low, and that's exactly why it's only those narrow cases where we would actually bring these motions. Further, if you don't believe that you're going to win the motion, then you don't want to give up your theory of defense early on in the process. So we are looking at, our estimates are that we would bring these less than 1% of the time. In fact, if you ask criminal defense attorneys how many people have actually filed a 991 for in-custody defendants, there'll be very few because they're so difficult to win, the standard is so low. But we really are focused on that fringe population, that small percentage where the DAs did file charges that are unsubstantiated and that we can weed them out at a very early process. We do give credit for DAs, they do not do this that frequently. But when they do, for that one person, those two people, or potentially 865 people, they should not have to go through the rigors of trial.
Madam Chair, may I just add, there are at least 3 people in this room that are very concerned about the cost. The chair of Budget Sub 5, Public Safety, yourself, and Budget Chair. I would not have moved this forward if I knew it was going to be costly, because obviously I would have to suffer the repercussions of it, trying to resolve it. Just looking at, on surface, we did not look at this as just the cost of what implementing this and doing the job. We're looking at how many times you can avoid having this long, costly trial coming one after the other, and having judges, and I think they do this now, they try to resolve a lot of cases before they get to court. And I think right now, if you look at the court system, they save money by resolving a lot of these cases ahead of time. And this is what this kind of promotes, to do that. As someone who's given hundreds of $millions to the courts to resolve their budget, I would not put a burden on them right now.
Thank you, Madam Chair.
Yes, thank you, Madam Chair, and thank you, Assemblyman Joan Sawyer. Yeah, I think a lot of what we're doing now is trying to simplify a complex system, make it easy to understand, and make justice not delayed, not denied, right? And I would just say that since the objection is based on finances and we don't really have data on that, I would urge members to think about the policy. For me, I'm going to be supporting the bill because I believe it is good public policy to speedily resolve as many cases as we possibly can. So, Assemblyman Joan Sawyer, would you like to close?
I just simply would say, let's, like was said earlier to 2 of the members, that we should focus in on the policy. I mentioned earlier, this is a sword of Damocles that lingers over people waiting for adjudication of their trial. That is not only the money that they spend on lawyers, but think about the individual that has to go to work every day. They don't know if they have to be pulled, what their supervisor may think, what their employer may think, or someone has to take someone to daycare, dealing with children. They're in limbo. And we guarantee everyone an expedient trial so they can have their jury or their criminal, or we would provide that for people with criminal prosecution. We should provide that for people at the misdemeanor level so they can continue their lives and be fruitful citizens. And I request you to ask for your aye vote.
Thank you. Please read the roll.
Hancock.
Aye.
Hancock, aye. Anderson?
No.
Anderson, no. Glazer? No. Glazer, no. Leno? Aye. Leno, aye. Lou? Aye. Lou, aye. Monning? Aye. Monning, aye. Stone?
No.
Stone, no.
That bill passes.
Thank you.
Thank you. And your next bill, Assemblyman Jones Sawyer, is number 2, AB 267.
Thank you. Madam Chair and members, AB 267 requires the court to inform the defendant that accepting a plea and a subsequent felony conviction has various collateral consequences. These collateral consequences include, but are not limited to, inability for enlisting in the military, inability to own or possess a firearm, loss of federal financial aid if the felony was committed while the defendant was receiving financial aid, potential diminished parental and child custody rights. According to the New York Times, fewer than 1 in 40 felony cases now make it to trial, as compared to 1970 when the ratio was about 1 in 12. Being charged and convicted of a felony can have dire long-term consequences, and much too often defendants are not advised of the long-term repercussions. AB 267 is not a new concept. It is simply expanding upon existing law. Consequently, currently, judges are required to administer an advisement regarding possible deportation or exclusion from admission to the United States for the conviction of an offense. This bill only adds to the advisements and will inform defendants of the collateral consequences of accepting a plea and becoming a felon. Here today to testify in support is Dennis Garcia, who is representing California Attorneys for Criminal Justice. I respectfully ask for your aye vote.
Thank you. Witnesses in support?
Good morning, Madam Chair. Dennis Garcia on behalf of the California Attorneys for Criminal Justice, the sponsor of the bill. As the Assemblymember mentioned, we think that this legislation is imperative for folks that decide to are considering a guilty plea or nolo contendere plea because of the adverse and potentially lifetime negative consequences of accepting a felony plea. We think that the folks that are considering these pleas need to realize the adverse consequences. This does not lower the ethical obligations that an attorney must provide to their client. However, at sometimes the client and the attorney have discussions, a couple weeks in advance, and we don't think it is harmful. Actually, we think it would be incredibly helpful for a defendant to hear these advisements once again by the judge. We respectfully ask for your aye vote.
Others in support?
Madam Chairwoman and members, Francisco Lovaco, on behalf of the American Civil Liberties Union, I want to say again, this makes perfect sense. More information is good information, especially with felony consequences on folks' heads. So we strongly urge you to support the bill. Thank you.
Thank you.
Good morning, Madam Chair, members of the committee. Tom Pedersen on behalf of the California Rifle and Pistol Association in support of the bill. Thank you.
Thank you. Others in support? Speakers in opposition to the bill?
That was different.
Sharon Riley on behalf of the Judicial Council. The Judicial Council is opposed to this bill. There is some concern about the transfer of the informing of the defendant about the collateral consequences of the plea, as opposed to the defense counsel providing that information where there can be more dialogue, et cetera. They're also concerned that the bill is vague to some extent because it does list several things that the court should require should inform the defendant about, but the list is not exhaustive. So there's concern about what does that mean for the court. If the court misses one of the things that could have potentially been an issue for the defendant, how is that addressed? And also the council believes that the method by which the court is required to inform the defendant is not specified and it could benefit from clarification on that issue.
Thank you. Others in opposition? Seeing and hearing none, are there questions or comments from committee members? Senator Anderson and Senator Stone.
I just want to thank you for bringing this forward. You know, we've spent an awful lot of money chasing down people that have no idea that they're on these lists and telling them up front hopefully will save a lot of time and money as we move forward. And I also think that there are so many things that come at you that while you may be told by your attorney, it may not stick. Having it come from the courts as well, I think, is also very, very helpful. I'd like to be added as a co-author if you make any amendments. This is a very thoughtful bill, and Madam Chair, I'd like to move the bill when it's appropriate.
It's appropriate. The bill is moved. Senator Stone and then Senator Glazer.
Thank you, Madam Chair. For Judicial Council, I always thought that a judge was supposed to navigate a trial and are supposed to exhibit some type of neutrality. I've always thought it was a defense attorney's responsibilities to negotiate with their client what their best avenue of defense is, what the ramifications of pleading to a felony may be. Do you agree that it's not the judge's job to inform the defendant of all the collateral consequences of a plea, especially when, as I look at the digest and I look at the parameters that would be imposed on a potential felon, it says including but not limited to. So to me, by having this language in there, we're basically giving a opportunistic time for an appeal to use basically a conflict, if you will, because of an omission that a judge may or may not have thought about that would be a right that they may be losing. And so I'm concerned about that. I'd like to get your opinion on that. Also, if they do agree to plead to a felony, isn't it a standard of practice that a judge will tell the defendant that they will lose their ability to buy a gun or possess a gun and ammunition?
There are some provisions under existing law that judges already advise defendants about. The concern here is that this is a very broad list, and in particular, they including but not limited to, and what that means, what that would entail.
So you would see, I would think, a lot of appeals as a result of that gray area.
We didn't consider that in the analysis, but there is an appeals process, so it's kind of hard to predict.
So is it your position that a judge should be reinforcing the rights that are lost if one pleads to a felony, or do you think that should be the responsibility of the defense?
The Judicial Council's position is that that's traditionally been the responsibility of defense counsel, but I think that the overriding concern is how broadly it's written.
In my report, it says that a defendant, if he or she accepts a felony plea or suffers a felony conviction, could sue the court for failing to adequately inform him or her of the consequences that a harm has been suffered either as a result of the way the information was provided in court or because the list did not capture every possible harm.
That's correct. That is one of the concerns that the court judges did raise.
I applaud the author's intent with the legislation, but I feel like there's just too many loose ends that are going to create frivolous lawsuits and provide yet another way for a defendant to file an appeal and have his or her conviction reversed. So unfortunately, I won't be able to support the bill today.
Senator Glazer.
Madam Chair, I do note that in the analysis it indicates that the governor, previous governors have vetoed legislation like this. I wonder if the author could explain whether this bill is different and whether it's responsive to any of the concerns that have been raised in previous measures.
I think that part of the challenge that we've had with previous executive governors is they don't want any undue burden on the courts. And we will work with the court to ensure that this doesn't become either financial or an undue burden of lengthening court cases. And then the more I look into this, and I'd like to thank the NRA for coming, because that's one issue I didn't even think about, people losing their right to own or bear a firearm if you accept a felony plea. And so there's a whole list, a cacophony of different voices that could come in here and tell you about what could be on this list. We have to figure out a way to let people know that. And I think that from the executive branch, I think we can show that it will not be an undue financial or exhaustive burden on the courts, especially if we just list it and have maybe someone sign off on it, but we do need to have some kind of consultation with the defendant to do that.
So there's nothing in what you're proposing that's substantially different than what's been proposed in previous years then?
You know, I'm not absolutely sure, but I can find out for sure and then get back to you.
Okay.
That would be great.
And then you did raise the another option, because I'm concerned about the broadness of this list. And obviously, we want a defendant to be aware of the consequences. There's no question about that. But you just brought up another alternative, which seems more attractive to me, which is to be able to present to the defendant a list as defined that allows them to sign off on it, so the court and everyone can be clear on that. That would seem to put a less of a burden on the courts and more on the defense counsel to have reviewed that list, almost as if you were reviewing a contract in a real estate transaction, so that they could be clear about those consequences and then have a sign off. So that certainly seems a lot more attractive to me. That would seem to advance the worthy goals that you have put forward, but allows the court and everyone to be clear that the defendant is understanding the consequences. That'd be something that you would consider?
Yes, and Senator Glazer, I'm trying to get this worthy goal done. I don't want the bureaucracy to weigh it down. And so as a former bureaucrat, I'm dedicated to ensuring that that doesn't happen.
So for me, and I'm new to this process, I'm uncomfortable with the bill as presented, but I think if there was a way to provide that same protection to the defendant with some sort of a checkoff, it seemed to me something that I would encourage. But in the
I mean, part of this is we don't, no, we're not supposed to go back and forth, but part of this is with the governor, I think is he likes for the administration, likes for the departments to come up with their own methodology. I think once the courts embrace this and they know that they need to do this, I think they will come up with a way to get this done where it doesn't impact them adversely. That was just one idea off the top of my head right here.
I see, but Madam Chair, it does seem like we're directing the judge to take some specific action. Does that leave leniency to the Judicial Council as to how they implement it, and would they be allowed to, in the implementation of this bill as written, allow for a checkoff to be worked out through their defense counsel?
That's the way I would read the bill.
Madam Chair, if I may? If I may, the way the legislation was written, it was written broadly so we could allow some flexibility with Judicial Council, because obviously, as the Assembly member stated, we don't want to add an increased burden on the courts.
Yeah, I think a way out of this bill does not go to fiscal committee, but I would suggest that if the bill passes today, the author might want to consider some of these things and possibly make an amendment before it's taken up on the Senate floor or whatever. Or we could conclude that we can leave it up to Judicial Council to develop a process, because that is where it would be now. And something like a checklist might be a very good thing.
I think for me at least, this is going in the right direction. I don't know if it's appropriate to hear from the Judicial Council as to how they would interpret the bill as written or an amendment as suggested in terms of their ability to.
You can ask them, in all due respect, I would say that legislating from the floor, I doubt that the representative of Judicial Council could make a definitive statement at this point.
So I can speak generally to our processes. We do have processes for adopting rules, for making new forms, et cetera. So anytime legislation is passed that may require that, that's something that our various advisory committees will look at and make recommendations to the council. As far as this specific bill, I don't know what the process would be.
Well, Madam Chair, can I ask a more specific question? As I understand the bill, it says it requires the court to inform. So I'm not as aware of how that is traditionally done within the law. So does it allow the court to inform through a checkoff that's submitted to defense counsel? Is that an option that the court would have?
The council would explore the various options that would make the most sense. It would also have the opportunity to get public feedback from courts and attorneys, et cetera. So So there are other instances, I don't know if it would be this for this one, but there are other instances where there is sort of a form or a checklist.
So, Madam Chair, then through the chair, the criticism was cost. And if we're hearing that somehow is avoidable, that adds more confusion to me at least, if we're trying to, again, the worthy goals of informing the defendant, but trying to avoid the costs. I'm not still clear about how we reconcile all that.
Well, let me suggest, this is a policy committee. It is interesting the bill was not referred to appropriations, must have thought it would be a minimal cost, and that a process would be developed. But I would urge today that we consider the general idea, which is that the court would make sure that a defendant who plea bargains, which there's a lot of pressure on people to do in our system right now, that defendant is aware of what the consequences can be. So that's why I'll be supporting the bill today. And I hope that clarifies.
Madam Chair, just to back you up on your last statement, we've heard from the sponsor of the bill that the intent was to allow for some discretion and determination by the Judicial Council. Costs, I'm sure, were a part of that consideration, and that this is normal process for our passing legislation and then for the implementation to be done through a rulemaking. So I don't think this is out of the ordinary, and I don't know that we need the bill to incur any additional expense, and this was its stated intention, as the author and sponsor have already made clear to us. So I'm happy to support the bill as well.
Okay. If there are no other questions or comments, there's been a motion. The motion is do pass. Please read the roll.
Hancock.
Aye.
Hancock, aye. Anderson. Aye. Anderson, aye. Glazer. Leno. Aye. Leno, aye. Lou. Aye. Lou, aye. Monning. Aye. Monning, aye. Stone.
No.
Stone, no.
That bill has enough votes and passes.
Thank you very much.
Thank you. Thank you all. Is Assemblyman Rodriguez here? Item number 8, AB 1104. Thank you. Welcome to the committee.
Good morning. Madam Chair and members, AB 1104 would clarify that a search warrant for controlled substances is already authorized in the Health and Safety Code by referencing such provision in Penal Code. Under current law, the issuance of search warrants is limited to cases involving felony offenses. Due to the recent reclassification of specific crimes, it has become necessary to clarify that the authority to seek and obtain search warrants for controlled substances possession is already provided in Health and Safety Code. AB 1104 would make a reference of such provision in Penal Code 1524, which is the statute that generally describes the situations in which search warrants may be issued. I respectfully ask for an aye vote. I have here with me the sponsor and co-sponsors of the bill who will introduce themselves for the record and answer any questions. Thank you.
Thank you.
Good morning, Madam Chair and members. Corey Salzillo here on behalf of the California State Sheriff's Association. We're the sponsors of the bill. As laws change, we think it's important to review them to ensure clarity, both for those who govern and for the governed. A question was raised about search warrants for controlled substances possession offenses. And so the bill merely amends PC 1524, which is the sort of go-to section for figuring out when a search warrant is able to be issued. This bill merely makes a cross-reference to an existing Health and Safety Code section that permits the issuance of search warrants and controlled substances offenses. For that reason, we'd ask for your aye vote. Thank you.
Thank you.
Thank you, Madam Chair. Sean Hoffman with the California District Attorneys Association, co-sponsor of the bill. I'd echo what was said by Mr. Salzillo. these two sections already kind of operate in conjunction with one another, but we believe that an explicit cross-reference would provide important clarity for law enforcement, for judges who may sign off on warrants, and for the folks who are governed by our warrant requirements. We ask for your aye vote.
Thank you.
Good morning, Madam Chair and members. Barbara Ferguson, representing Sheriff John McMahon, San Bernardino County, in support of AB 1104.
Thank you.
Good morning, Madam Chair and members of the committee. I'm Marla Marshall on behalf of Sheriff Bill Gore and the San Diego County Sheriff's Department in support.
Good morning, Madam Chair. Tom Sheehy on behalf of Cal Chiefs, and we're here to ask for your aye vote on this measure. Thank you.
Good morning, Madam Chair. Lieutenant Wayne Billowit with Los Angeles County Sheriff's Office in full support of the bill. Urge your aye vote.
Madam Chair, members, Sean Rundle with the California Peace Officers Association, also in support of the measure.
Madam Chair, members, Matt Seiberling on behalf of the Association for Los Angeles Deputy Sheriffs, the Association of Deputy District Attorneys, California Association of Code Enforcement Officers, California College and University Police Chiefs Association, California Narcotics Officers Association, the Los Angeles Police Protective League, and the Riverside Sheriff's Association, all in support. Thank you.
Thank you. Are there speakers in opposition to the bill? Seeing and hearing none, questions or comments from members of the committee or a motion? Senator Stone.
Thank you, Madam Chairwoman. Assemblyman Rodriguez, thank you for bringing this clarifying language forward. I'm happy to support the bill, and I'll move it.
Thank you.
Thank you. The bill has been moved. There are no other questions or comments. Would you like to close, Assembly Member?
I respectfully ask for your aye vote.
Thank you.
Hancock.
Aye.
Hancock, aye. Anderson. Aye. Anderson, aye. Glazer. Glazer, aye. Leno. Leno, aye. Liu. Is that an aye? Okay, aye. Monning. Monning, aye. Stone. Stone, aye.
Okay, that bill passes. Thank you very much.
Thank you.
Okay, so we're going to open the roll for the absent members, which may only be me today, but let's see.
Item 5.
Okay. Item 5, AB 860 by Daley. Please call the absent members.
Hancock.
Aye.
Hancock, aye.
Item 6, AB 929. Oh, the vote is 7-0 on AB 860. Okay, AB 929.
Hancock.
Aye.
Hancock, aye.
That vote is, bill is out, 7-0. Okay. Okay. Excuse me. And then item 10, as amended.
Hancock.
Aye.
Hancock, aye.
7-0. Thank you. That concludes the agenda. The meeting is adjourned.